And I want to thank you for coming this morning and welcome you to this initial conference in case 15E0751 in the matter of the value of distributed energy resources. To my right is Chair Zibelman, and to my left is Scott Wiener. We're going to start with the chair introducing some of the folks here.
You want to just, Rudy, do you want to start? And I'd like to know
I'm Rudy Stegemiller.
and who you represent, and
I'm
except for
Rudy
the people.
Stegemiller, representing the people of the state of New York. And Audrey Zibelman.
I'm Peter Olmsted with staff.
Marco Padula from staff.
Mike Sumo, staff.
Steve Wemple with Con Edison.
Student activists, kind of in Illinois.
Valerie Strauss, Association for Energy Affordability.
Doug Elman, Solar City. Jamil Khan, Solar City.
Carlos Gonzalez, Solar City.
Sean Guerin, Boat Solar.
Dave Gall, Pace Energy and Climate Center.
Bob Curry, Solar City.
Hi, Kelly Joseph with Energy.
Pete Fuller with NRG.
Joe Halley with Central Hudson.
Carol Texera, National Grid. Lauren Mazzoni, National Grid. Janet Audinson, National Grid. Ann Reynolds, the Alaska Clean Energy of New York. Colleen Gerwood, staff.
Richard Berkeley, Public Utility Law Project, representing the low-income utility consumers in New York.
Adam Conway on behalf of New York City.
Amanda Trinzi on behalf of Ethical Electric.
Kathleen O'Hare, Department of State Utility Intervention Unit.
Greg Collar, Department of State Utility Intervention Unit.
Warren Myers, staff.
All right, you piqued my curiosity. What's Ethical Electric? And does that mean the rest of us aren't?
We're an ESCO, and we deal exclusively with renewables.
Okay, welcome. Well, first of all, thank you all for being here. This is, actually, I would say this is our first proceeding in 2016 dealing with REV, so it's a great place, I think, to start. You know, one of the things that we've been talking about at the agency is that if you think about it, starting in 2013, when the commission issued the EAPS order saying, look, things have changed and things have got to change in the way we think about clean energy, and that we don't want to think about it anymore as ancillary to what we do when we can develop, produce, consume energy. It's going to become integral. And we really need to think about how changes in technology really need to get us to change the infrastructure. That ideation led to the development of Track 1, the REV initiation, which also led to the development of us rethinking about what we wanted to do around clean energy in general, which is the NYSERDA Clean Energy Fund that is going to be up in front of the Commission, and all the various elements that sort of followed from there. And the way we're beginning to think about things is that between late December 2013 and now January 2016, it's all been about ideation. Where do we want to go? How do we set the vision? What's the potential for this, for really what we can do in the electric industry moving forward in the 21st century? And we've done a lot in terms of moving this, coming up with the concepts, which it's obviously resonated with a lot of people, probably resonated across the world in terms of this seems to be the right direction to go. And we've launched, as you all know, because you tell me all the time, any number of initiatives to get this thing done and to get it done right. Now, as we move into 2016, we're really at I would say, the third layer of the onion, where we're really starting on the execution documents. Okay, we know where we want to go. Now we need to work on the details on how we're going to get there. And this proceeding in particular, I think, when we, in some years back, when we think about all the things that we've done around REV, will, I believe, stand out as one of the preeminent proceedings in really thinking through what's the future of electricity. Because one of the things, and as many of you guys know, I came from the wholesale arena where locational marginal pricing was developed. It was, when we started this at PJM, it started with some academic papers written by Hogan. There was a lot of debate. There was a lot of stakeholders. It took years to get people there. There were lawsuits from people that people in this room don't even know, like Enron, who don't even exist anymore, about it. But it was debated across the country and ultimately became the convention that is not only used across the United States, but is used actually across the world, because it's recognizing that the price of energy ought to represent the flow of energy, and that the marginal value, when you have something that is instantaneously consumed and produced, is really the value of the product. And that really drove a huge amount of efficiencies across the system, that plus, creating larger control areas, because now you had the diversity of resources, and you could really represent the instantaneous value of the ability to produce at a spot. Where that was left was really at the meter, or at the distribution substation. We didn't go below that because we assumed that there wasn't much we can do on the dynamic side of the grid when we got to the distribution level. That was proved wrong, frankly, between 2005 and now, when we saw the potential of demand response and using spinning reserves around locational energy and all sorts of things that helped actually improve the efficiency of the bulk power system. What REV is fundamentally about is saying, well, wait a minute. We've demonstrated throughout the country that we have accurate pricing at the bulk power level. We drive efficiency of generation. We drive better investment in generation. We drive better capacity factor of generation. We drive better utilization of transmission. And all that assets became sort of a benefit around managing price, integrating renewables, because with better information, better accuracy, and we were actually running the grid based on how the physical properties of the system worked. What really this is about is taking that same learning and saying, with the fact that we want to move to a much more dynamic load, where we have the capability of really managing load as a resource, which will drive further efficiencies of the grid, which will help with price, help with integration of renewables, give value to consumers, and really take it from the consumer way out, we need to use really the same conventions. And so what we're looking to do in New York is recognize that one of the hallmarks of good markets is pricing accuracy, information transparency, and providing fair and precise value for the various activities on the grid. And that, through that, what I believe we'll get is the confidence that when folks make investments, they know where to make their investments. We get rid of the asymmetry that exists today, and then they're going to be able to manage their expenses, and so which will, for us, help get to where we want to get with REV, which is recognizing that technology is not the issue. It's really having good fair pricing, good markets, good regulatory design, and good compensation for everybody around. So what I see this proceeding about is essential to what everyone in the United States is talking about, getting to much more transactional grid, creating much more sophisticated uses of the system, and really getting the full value of the technologies that are being developed. I think that you're going to see similar proceedings, probably most likely in California, where a lot of the same debates are going on. I think there's a little bit about this going on in Hawaii. But I think that, frankly, when it comes down to the forum, where the best thinking is going to occur, where I think we're going to see a path forward, I think it's going to be New York. We have, obviously, through the work that we've done through the MDPT and what we're doing with DSIPs, I think we've all increased our energy acumen. We certainly have the right dialogues, the right conversation going. And what we would like to do on this proceeding is really start thinking about, okay, everyone knows where you want to go. There's been lots of papers written in IEEE, and in almost every article anymore about the transactive grid. Nobody really knows the path forward. And I think that what we're looking to do here is strike that path forward where we think about where do we want to be at the end of 2016, where do we want to be at the end of 2018, how do we start implementing this, knowing that we need to crawl, walk, run, but really thinking through how you get from the grid of today, where you think about a bundled distribution system, to where it's unbundled and you're getting real value back. So I'm very, I think, I keep telling staff this is probably the critical issue we have to get right, because everything else will almost flow from this. I think that, we have the right people, certainly internally, to work on it, but this is really going to be a collaboration, we're all going to pretty much, I think, succeed if we look at this from the standpoint that everyone's talked about it. There are a lot of good ideas out here. This is the opportunity to really execute well, and I think, most people who in this industry would agree, once we got to LMP, and the markets in the Northeast that used it, they're a lot more efficient, a lot better, a lot more equitable than markets that we had before, where in fact we were looking at things like contract path and et cetera, that a lot of assets were left sort of behind the congestion point and didn't get a lot of value. So I'm very much excited, enthused that you're here. Appreciate, as always, your participation. I recognize that we are carrying a lot of burdens in New York, but I think you would all agree it's, you can't imagine a better place to be if you're going to be in this industry, because it's all happening here. So thanks a lot, and hope you have a good day.
Thank you.
Thank you very much, Chair Zibelman. I have to tell you, it is an exciting time to be working at the department. It really is. I'd like to turn the microphone over to Scott Wiener to talk about the overall objective in this case and some of the salient points we need to deal with.
Thank you. I'm going to be turning the mic back over to the judge in a few minutes, but I did want to build on a couple of the comments that were just made and set a context for how we're going to go forward. As was mentioned, the process that's being started today is different. There is no staff straw for everybody to comment on and shoot at. And deliberately, we didn't invite any particular or group of stakeholders or a stakeholder to put something out. Instead, we intentionally wanted to give everybody, whether it be individually or collectively, an opportunity to go first and to be able to present for consideration best thinking from individual parties' point of view or groups of parties' point of view as to how we should be approaching this issue. This proceeding will be managed by Judge Mullaney, who we will all get to know a lot of. Staff will be an active participant, and we'll talk a little bit about how we see this process unfolding. Needless to say, as Audrey mentioned, the proceeding addresses a core concept of REV, more precise and accurate pricing of the value of DER. And as we think about the future of value and compensation for DER, we of course think about how do we transition from the current paradigm of net metering. We all know that the Commission's order requires staff to present a first step, sometimes called a bridge, sometimes called an interim valuation methodology, but call what you may, it will be a first transition from net metering as we now know it. It may be comprehensive, it may be a slice of the market. That's something we'll all figure out collectively. But it will be the first step along that glide path that will get us to full valuation. That initial step, staff is required to come up with a presentation and a proposal for enactment by the Commission. It's now December of this year. We used to be able to say next year. It now feels a lot closer for all of us on staff. But that's what we'll be working on collectively. We describe this amongst ourselves as a forward-looking process and proceeding. And you'll hear this a lot from me and from others. We really don't want to relitigate or re-argue the issues and the battles and the wars of the past. We need to learn from them. There are lots of lessons learned, and people and parties should feel free to draw upon that learning and that experience, but we really do not want to relitigate issues about how things were done in the past. We want to be talking about how things should be being done in the future. How do we acquire the more precise, the better pricing of DER? And how do we convey both the calculation of the value but also the compensation for that value? This kind of process has some implications. Much of the process itself, and Judge Mullany will talk about this, is to be determined. Some of my colleagues here have heard me muse about the need to embrace ambiguity. I'm going to suggest that's going to be the case here too in terms of process. Things will become a lot clearer as we unfold, and we'll talk about the first major step, which is the opportunity to file responses to the questions that were promulgated last month in the form of proposals or suggestions, and that's in December. April. That date in April was picked intentionally for recognition that everybody in this room has a lot going on, and there may even be another proceeding around a clean energy standard that may pop up very soon that we all, or almost all of us, will be involved in. But we also recognize that to prepare the kind of presentations, to make the kind of suggestions that we know you want to make and that we're eager to have presented takes time. It's not something that can be turned around in 30 days, hence the April date. That said, the December clock is ticking, and we need to keep that in mind. Our goal in drafting the questions that were accompanied the notice last month of this proceeding is intended to focus on concepts and mechanisms, not precise arithmetic or mathematical calculations. We want to begin to start with concepts, approaches, and mechanisms. What are the criteria and the components? Part of that reason is, as you know from the notice, we're anticipating the opportunity for further discovery by parties to be able to drill into the concepts and the proposals that are eventually presented. We're trying to avoid, and intentionally avoid, and studiously avoid, a lot of process and calendar time being burned right now while people ask for data, which may ultimately be relevant. And as we sat and thought about this process, we said, wouldn't it be interesting, or wouldn't it be, could it be effective if we could somehow come up with a common data set that everybody could agree upon, either hypothetically or in fact? And the answer is, yeah, it would be really nice, but I don't know, frankly, whether we have the time between here and April to spend a lot of time doing that. So we ask that as you put together your proposals, as much as humanly possible, stay conceptual, stay based on criteria, describe mechanisms, and describe the kind of data that you would need in order to take your proposal to the next step. That will help us begin to think about how we can consolidate data requests. Now, all that being said, and please don't take this as an open invitation, you may find that there is some form of data that is essential for you to do the work you need to do. And Judge Mullany will talk about how we perceive those kind of data requests taking place in the period of now to April. But again, please try to stay conceptual and focus on the mechanisms. When you do ultimately present your mechanisms, as was alluded to in the notice and so we talked about some more, and particularly if you do present calculations, please anticipate that there will be a request for the information and the processes and the assumptions that underlie those calculations, so you can make everybody's life a lot easier by disclosing your work and attaching it to it. Now, a final suggestion is, where possible, if possible, consolidate your efforts. We know that there's been some collaboration going on or some talk about some parties getting together to pool resources. Needless to say, that would be a process asset. That would be a process asset. So we welcome you to this proceeding. We will be spending a lot of time together. As Audrey mentioned, this is probably everything we do here is important. Rudy pointed out to us recently that in prior years or in other jurisdictions, any one of the things that we're going to be doing this year is a major year's activity. We're going to have at least 3 or 4 of them going on. Between this, the forthcoming Clean Energy Standard, Track 2, and its iterations. So this is important work. And although by its nature, development here is adversarial in a legal context, in a professional context, we want it to be collegial. We want to be able to enter this so that all of us, whether it be staff or the various parties, look at it that we have a common problem to solve. And in doing it, we have to address all the issues and concerns of each other. And in that context, we look forward to working with everyone. I know Judge Mullaney wants to discuss process, and following which myself, my colleagues will be available to answer any questions if we've managed to thoroughly confuse you between the notice and these remarks. Thank you.
Thanks, Scott. I'm going to start out by sort of distinguishing some of the elements that Scott just described from what I perceive to be my role as the ALJ in this proceeding. And I'm going to start on a sort of personal note, which is I happen to be married to a wonderfully intelligent woman who is very multidimensional in the way she approaches problems, and I tend to be very linear. And so when Scott said the December clock is ticking and we need to keep that in mind, that was what resonated with me. When Scott talked about a collegial and collaborative process and working together, this is sort of the process that I hear. And this is meant as a sort of graphic illustration of this. So, and I understand there's an inherent tension between these two approaches. And I understand the value of an iterative process, and I hope you appreciate that I'm trying to strike a little bit of a light note because so much is going on. The burdens on the parties are tremendous. The stakes are tremendous. And when we are under those circumstances, humans have a tendency to polarize and to become litigative. It is human nature. And so the struggle that I'm going to have to oversee is to fashion a process that's iterative and to the maximum extent possible collegial and collaborative while still driving the herd toward the gate by December of 2016. So that's just the overall context that we're dealing with. So having sort of set that table, the first thing I'll say is that the deadline for the responses to the questions and the request for proposals is April 18th. And so that's, for me, that's the first deliverable date, and that should be the focus of everyone, I would hope, in their initial steps as part of this very important process. The second important thing I want to mention is that I know many of the folks in the room are already very conversant with the department's procedures and processes and the ramifications of being a party and so forth. But to the extent that we have new players in the room, and I think and hope that we do, I'm going to give a little bit of a background on discovery and how that works and how we anticipate that working in this case. We are going to allow discovery essentially right away. People can begin inquiring of one another, trying to seek information that will help them in the development of their proposals and in the development of their responses to the questions issued back in December. Discovery is a privilege reserved to parties, to proceedings. So I want to talk briefly about how do you become a party to a proceeding and what are the ramifications of being a party to a proceeding. It's very much distinguishable from somebody who's just on the sidelines listening in. To become a party to a proceeding, you have to, under our rules, and it's Rule 4.3 C1. The criteria or standard is party status will be granted if the intervention is, quote, likely to contribute to the development of a complete record or is otherwise fair and in the public interest. So that's the regulatory standard. In practical terms, what it means is that parties, entities that seek to become parties, are, in a sense, in essence, they are committing to contribute to the record. And so to the extent that there are formal filings, there is to be testimony filed if that in fact becomes the case. The parties are obliging themselves to actually actively participate. The benefits of it is that you get to participate. You get to conduct discovery. You get to submit formal testimony. You have an active role and can hopefully influence what the record looks like by the end of this. Mechanically, let me just talk about, are there folks here who are not familiar with how to become a party? Because I don't want to waste people's time if everybody knows the mechanics of it. Okay, good. So everybody's familiar with it. If anybody isn't familiar with it and they want to come to me later and ask me for information about it, please do. Otherwise, I'm not going to take up a lot of time on that. In essence, you can go to the website and sign up to be a party. Alternatively, you can be on the service list, in which case you just get copies of filings that are made and significant events in the case. Discovery. The rules for discovery are under Part 5 of the Commission's regulations, and I'm going to oversee the discovery process. But I want to stress, and this is in fact stressed under Part 5 as well, that to the extent that we're under a tight deadline and we're dealing with a collaborative collegial process, but we have a lot to do in a short time frame, I really want to urge everyone to focus on informal communications first. If you're looking for information from another party in the case, please reach out to them informally by telephone. Talk to them about what you think you want. Come to some understanding, if at all possible, as to whether or not the party being asked to produce information has that kind of information that you're seeking. And do they have it in a form that they can produce without a great deal of effort? Try and work with them to streamline that process so that it doesn't evolve into disputes. Again, this dovetails with what Scott was saying about at this stage, we are really trying to focus on conceptually what data sets do the parties think they will need in order to fully articulate their proposal for a value of DER process. So to the extent that you can avoid disputes about particular data, I think, and formulate a proposal based on categories or types of data, that will help us work together toward what I hope is our common goal. I have to tell you, I'm kind of concerned because we're talking about transparency, price transparency. And to be very frank, the utilities have very significant concerns about sharing the data about their system in this day and age. So I do think there's a risk that this can devolve into a very litigious proceeding. And so I urge everyone to try and work against that, to keep your eye on the goal, keep your eye on the ball, and to the greatest extent possible, work with each other to find solutions that will allow us to move forward. This is part and parcel of what Scott was saying about keeping your eyes and your focus forward. Is this resonating? Do people understand where I'm headed? Okay. All right. Good. Thank you. I'm also pragmatic, so I understand that, me sitting up here and telling you to play nice isn't necessarily going to result in everything, but.
Everybody here, please.
So. Okay. One other point I wanted to mention is that as part of what Scott had mentioned, that this is going to be an iterative process. There are a host of mechanisms that we can potentially use to move this forward, whether they be procedural conferences or technical conferences or the filing of written testimony, et cetera. They all fall on the spectrum of dispute resolution, if you will. So I'm not going to predict how this is going to play, although you can tell from my prior comments how I hope this is going to play. So I guess the next step then is to ask, because when we're formulating these questions, we took our best shot at trying to kick off this conversation by focusing on areas that we think are going to be of primary concern. But I want to open the room up, if I can, to get a sense from those who took the time and trouble to come here today to just give us a sense of where your concerns lie, and so we could, and I guess it's kind of what I said to Scott is kind of an informal poll. We don't have an agenda in terms of Q&A. I'd really like to get a sense from the attendees as to what their big issues are, process-wise. So if I may invite comments, feel free to raise your hands. Sir.
Yeah, sure. It's Adam Conway on behalf of New York City.
Mr. Conway, thank you. Welcome.
Yeah, thank you. And, I appreciate the time and effort that's gone into putting these questions together, and I can understand the concern of looking forward and figuring out what the next step is. But I had a concern on one of the questions, specifically, it's footnote 10 of the staff questions where basically it says you're not going to entertain proposals to maintain net metering in its current form or a proposal to eliminate net metering without establishing an acceptable successor. And I guess my concern with that is we talked a lot this morning about how much is on the commission's plate and is on staff's plate over the next year, how short a period of time we have to do that, and how you want people to sort of work collaboratively towards a solution. And I guess, assume that happens, I could assume one reasonable outcome of that would be that some parties might say we should keep net metering in its current form, at least for a short or some additional period of time until we've had time to develop or more time to develop a successor. So I guess I was just concerned that I feel like that footnote 10, it's a little bit too premature to just say we're going to, off the bat, put these off the table.
That's fair, and as you're raising a question, I realize that that footnote probably could be very confusing. Mentioned. So I would urge everybody to think about the footnote in the context of this first step. In other words, what we didn't want to receive in April was a proposal to say, just get rid of net metering and the world will be fine, or net metering is great, why are we even worrying about this? We really need to be pushing ourselves down the road of valuation of DER. I will leave open the possibility, although there'll be a high hurdle, that sometime much later in the year, there could be a shared epiphany by all parties saying, maybe we need a little more time to address an issue. So think of this in the context of April. It's number one. Number two, the staff comments in the Track 2 white paper from the summer that talked about net metering and raised the prospect that the evolution of net metering, whatever form it takes, might not necessarily apply in the first instance to the entire market. When we talked in the paper about the possibility of traditional customers who might have rooftop systems, maintaining net metering as we know it, that possibility remains. It has its roots in Track 2. We're not committed to that as an outcome. We're not opposed to it as an outcome. We're just trying to avoid what may seem self-evident of one or more parties saying, everything's fine, just stay what it is. We don't want to be starting from that point.
Can I just add a little bit to that? Is another way to look at that is that the positions of just maintain the status quo and net metering for all customers, or just abolish net metering, are positions that are very familiar to us already, and that proposal wouldn't add anything to the discussion because it's something that everybody's already very familiar with.
I guess I would sort of disagree with that. I mean, I understand that everybody's...
Disagree with what?
All
of it, or?
No. I mean, I agree with you that everybody's familiar with the arguments. I mean, I think you could say that there's new evidence to consider, most notably this NYSERDA study that was just published a couple of weeks ago to say, this takes a look at what net metering means in the context of New York State. This is information we didn't have previous to that, and nobody's really looked at that in the context of a PSC proceeding when we're making decisions on net metering. All I'm saying is, I just think that if, and I understand what we're looking to get here, but I just think if somebody does come out with a proposal that might conflict with footnote 10, I don't think it should be disregarded out of hand, is all I'm saying.
It's going to have a very high hurdle, and the underpinning of this proceeding and the underpinning of REV, and at least the underpinning of, I would say, the commission and the staff's view of net metering is that it's a blunt instrument that's applied in a universe of imprecise pricing through average rates. And we spend a few pages talking about that in the Track 2 white paper. So this process about how do you value DER, and if somebody wants to make the argument that net metering is the most precise method of valuation, I think it'd be an interesting thing to read, but may be off point.
One more clarifying thing, sorry. Sorry. Just
No, you got to come up to the table. If you're gonna talk, Jamil, come up to the table. But
So, you mentioned something earlier about how you could just take slices of customers, the entire customer segment, and say we want to change this slice of it. In your mind, that's not conflicting with footnote 10.
Certainly, it doesn't conflict with footnote 10 with respect to what that first interim transitional approach might be.
Thank you. Jamil Khan with Solar City. I just have a question, or actually more of a comment that I'm hoping you guys can respond to in context of Track 2 and the interest in the staff proposal to look at rate design changes. And it strikes me that if we enter into this proceeding and look at different valuation methodologies and mechanisms, and given the fact that net metering as it exists today is based on the existing rate design, I'd like to hear from you guys how that those two proceedings will actually affect each other, where we figure out a compensation mechanism, but we also have a moving goalpost when it comes to the actual savings proposition for consumers based on the rate design that they're subject to.
So my response, and I'll certainly invite my colleagues to chime in also. So from the perspective of this proceeding, I mean, as we tried to capture in the questions, and it was discussed in the Orange and Rockland order, rate design is an important component of addressing this issue. One can't do it without considering rate design issues. We are dealing now in multi-dimensional multiple proceedings that are happening simultaneously. So it's not inconceivable that as the commission begins to look at Track 2 and begins thinking about what it may want to be saying in 2016 about Track 2, it may say, depending upon what's happened in this proceeding, that it's going to demur to this proceeding. It may be that the commission articulates in Track 2 some policy direction based upon the comments received about rate design, which will provide a little greater guidance here. So rate design is on the table here, and this is part of the iterative nature of the process. There's no bright line right now, and to state the obvious or address the other elephant in the room, to use that metaphor, in the not too distant future, there will be a clean energy standard proposal coming out, and which is very much in real time being developed and being thought about and being evaluated. That will come out in the form of a staff white paper, and that obviously will have some interplay with what's going on here. It is by definition iterative.
Yeah, I would just echo what Scott said and point people to question 8, which definitely implies that rate design is on the table, and certainly appreciate comments and feedback as part of your proposals in that respect.
And also, bear in mind the distinction between developing interim approaches and long-term approaches. long-term changes, whatever the commission does with rate design, so, fundamental changes to mass market rate design, first of all, require a whole different metering regime, which we don't have. So the immediate job in front of us is developing an interim mechanism.
Scott, Your Honor, the city referred to the E3 NYSERDA paper that came out last month. Will that be brought into this docket, and will we have an opportunity to understand some of the analysis in that? Because it seems like that certainly relates, although
Yeah,
it was in a different docket number.
Yeah, it's certainly right. It came out of a different docket number. I guess formally I'll defer to the judge. Yeah, it will be brought in, but we do want to make E3 available to be able to both provide a presentation of the report as well as be available to respond to questions about the report. We're trying to determine the best way to do that. It may very well be by technical conference where they will be present, but that opportunity will be there.
And similarly, I don't know what the time frame is, but I expect other parties may introduce their own work products, and so at some point we may want to have similar
Absolutely.
technical or
Yep.
forums to introduce and explain comparable work products.
Absolutely. Stu, come on up.
Hi, Stu Nachmius for Con Edison. Just wanted to ask a question as I think about Audrey's comments this morning and the questions that were asked. As we saw the wholesale markets develop, what developed is a significant role with a retail choice paradigm for third parties, where third parties are very active in terms of bringing wholesale supply to customers, perhaps even aggregating demand response, right? That hasn't been new, and bringing that to customers. As we contemplate the value of D, we're now thinking about rate design, which is an important part of that, but also the compensation for the value of D. The issue of the role of third parties in that, and how third parties might then work with customers is an important part that ought to be considered in this. And I didn't see anywhere how the role of third parties might play into this with respect to how customers then, actual residential, small commercial, actual customers then participate in these in this new paradigm.
Yeah, well, so I'll speak as one of the drafters of the questions, and others may or may not want to chime in. I will concede that my focus was on inviting responses that dealt with mechanisms and the criteria for mechanisms. And your question, Stu, I see it could be relevant about how those mechanisms operate. It might include the role of third party, in which case that should certainly be part of the response. But at the end of the day, what we're looking for in this first instance, the focus of it, it's not exclusive, but the focus of it, is how do you determine value? And if third parties have a role in value discovery or in determining value, then it's entirely relevant. But how do we do the calculation? How is value determined? How is it discovered? And how is it provided?
Yeah.
I'm sorry.
Just to follow, I think that's true, and I go back to the wholesale markets. I think that was an important part of the focus. But when we were developing the wholesale markets, we also always had in the back of our mind that customers weren't going to be bidding or buying energy on a 6-minute basis.
No, that's very
that was
true.
always part of that. Yeah,
So that may be, but again, using that model, there's no question that the role of third parties is going to be an important part of market design.
Right.
We're just trying to stay at the focus, suggest how people respond, but how do we determine value and how is that value conveyed by in form of compensation?
Okay.
Hi, everyone. This is Anne from East New York. I have a timeline question first. So the deadline applies to developing interim bridge methodology. Is there a track of the full evaluation methodology?
No, there's no deadline per se yet, and there is a recognition that realistically it's going to go into 17. Now, maybe we'll, hit a mother load of creativity and insight, and we'll be able to do it by then. But the expectation is, and which is why we call it a bridge or a transition, is that that's going to be a longer process.
Are you imagining that when you say some slice of the market, so there would be some definition of applicability that this new successor would apply to, do you think that that necessarily needs to be the same for the interim methodology as the full valuation model?
I don't, and I don't mean to be cute by this. I have no preconceived notions, and I'm leaving open the possibility that either an interim or a final could address some or all of the market. So it could go either way. Think of my response rather than it's not being evasive but expansive.
Okay. I have another one, but is there?
Well, let's see if anybody else has one. Well, I guess you get to go again.
My question is about existing net metering law, and if the commission already has a plan in mind about how both the bridge and the final will integrate with existing net metering law, or if we should be expounding on that in our April proposals.
You should expound upon it. We have no thoughts.
Okay. I'm done.
Peter.
Good morning. A couple of quick things. One, to get back to the discussion and about information, common data set, and so forth. I just want to make sure that sort of level set here. And I should have. On page 5, it talks about ongoing research,
right,
the development of tools, and so on and so forth. The work will be concluded soon and made available. Right. Is that the NYSERDA E3? Is there other work going on? Is there something else we should be expecting from the commission as sort of a data set?
Yeah, there are three things we're working on. The legislative E3 net metering study is one, and of course that's now out in the public domain, if you will. We are also working on, and I'll tell you we're working on it, I want to see what it looks like, a bibliography, which is just meant as a convenience. None of this is intended to represent positions of the staff or the commission. We're just trying to gather up documents that we think may be relevant and make them easily accessible to parties if they're not otherwise familiar with them. I dare say that any list of 10, you're probably all familiar with at least 9 of them. But we want to make them available in any event. To echo a comment that was made earlier, if any party has a report that it thinks it's relevant and just wants to get it out there for the benefit of others, that can be done through submission through the judge. There are a couple of studies that are ongoing that, again, don't necessarily represent staff's point of view, but studies that have been commissioned by and or with NYSERDA for the purpose of getting background. When those reports are finalized, they'll be made available, similar to the E3 study.
Okay. One other sort of procedural question, just to confirm, Your Honor.
Must be talking about you.
Yeah.
I think I answered it. Hey, you.
The paper notice, what have you, refers to the possibility of additional sessions between now and April, but at this point you have nothing planned or scheduled. Is that fair?
That's a fair statement.
Okay.
And part of one of the purposes today is to seek feedback from the concerned community about whether there's a perceived need for additional process in advance of that date, and if so, why, and what form might that take.
Well, to do that off the cuff, on the fly, at the risk of, making us all get back together, I think, given the time between here and April, and I don't know exactly what it is, but yes, several sessions probably are helpful, whether it's, a presentation by E3, a presentation by the utilities, a presentation, and again, I don't know exactly the content, but I think there should be an expectation, frankly, that we should have a few more sessions, if nothing else, to all get around the table and bat ideas around. Because much as you recommended, Your Honor, that the idea of those informal communications, I think, is hugely valuable in what is ultimately a collaborative process. And while we all have phones and we all run into people in lots of places, simply the act of getting together could, in fact, be helpful to move that forward.
That's a good point. So make a couple observations. Number one, from I think staff's point of view, we certainly anticipated further gatherings post-April. And I understand from your comments why they could be relevant and valuable now to April. Notwithstanding the fact, I suspect we're all going to be gathering many times for many other conferences, but that doesn't negate the value in this the value for this proceeding. So I'd like to make a suggestion, subject to the judge's administration, that if you think that that's the case, please make a submission to the judge as to precisely what the topic is, what issue you want decided, and how you would like to see that done, and that can then be considered. Second thing I'd like to ask, we all know each other, we all interact with each other, but because of the way we're trying to run this proceeding, if any of you have questions and you normally feel inclined to pick up the phone to call me or call any of my colleagues for this matter, please don't. We're trying to run this formally and transparently. And I would urge you to present your question to the judge, and I will make a promise that it will be answered in a public way post-NDMM within 24 hours, so everybody can have access to that same answer. I don't want anybody to feel that, one, I don't want any of you to feel that some people have channels that others don't, and secondly, I want to avoid us getting a series of phone calls answering the same question many times.
Judge, on that note, I believe, like in rate cases, that when a party just serves discovery on another party, all parties are copied on that discovery request,
That's correct.
as opposed to sending a formal email out, which we usually do. Can we just have all parties now agree to send the request to all parties and all responses?
I would endorse that approach, definitely. In the interest of trying to move this forward and make sure that, as Scott was saying, this is a transparent process.
Okay, thank you.
Thank you. Well, come on, but Solar City had a voice. Wait 1 second.
All right.
No,
Hi,
go ahead.
I'm Amanda on behalf of Ethical Electric. So one concern Ethical has is, the interim to the interim, kind of what's going to happen now for net metering projects that want to go forward and be developed, and even Community DG, which is very dependent on net metering, and we're wondering how ultimately compensation may change when the interim successor goes into effect. So are projects that are developed in the next year going to be subject to what's current now, or the successor?
I'll answer that vaguely with two vague responses. One is that the Commission certainly respects and protects contractual rights. Right? So the idea of grandfathering is one the Commission has responded to even the past year that I've been here in a couple different settings. So it gives you some sense of how they think about that issue as a whole. That said, I think, and this is not meant to be in any way directional, that the question you raise is one of the questions to be tackled. But right now, the paradigm is a net metering paradigm. That's the current state. And that will be the state until something changes. And if people are paying attention, something may change by way of policy by the end of the year, but we don't know what the implementation of that is or how it would be implemented. And as those words flow down my mouth, I want to acknowledge that it impacts one of the core principles that we adhere to, a couple of them, of stability and predictability. But there's no way around that, and we'll do our best to respect stability and predictability.
Okay. Carlos Gonzalez with Solar City. Just trying to get some clarification on the logistics. So the language in the notice states that as much as possible we should try to stick to the benefit cost analysis framework, sort of like established categories. And at the same time, there was some language there that there was going to be some update or clarification as to, some updates to the benefit cost analysis
Yep.
framework. So I'm just curious when we're expecting to get that.
Soon.
And so
Soon,
is the
very soon.
is the scope potentially expanding those established categories, or what? We're trying to get a sense of what's the nature of those updates.
It would be in the nature of a commission response to the framework white paper that staff issued on the BCA framework and all the comments and reply comments that were received to that. Soon.
Okay.
Very soon.
Okay, thank you.
By all means.
Can I just ask a process question of the judge? Are you anticipating issuing a recommended decision in this proceeding?
We haven't reached any decision on that yet,
Okay.
in terms of the form.
Okay. It's possible.
I wouldn't rule anything out,
Okay.
yeah.
You should be nice to them in any way.
Yeah.
Will staff be issuing anything either?
Anything is possible. I mean, again, I want to be very transparent. We are really keen and eager to get to April and see what the parties have to say. And I think the next steps after April 18th, I really believe will become apparent after we see what's in and what the next steps are and how we do that and what form that process takes will become a lot clearer. Going once? Anybody else? Motion to adjourn? So moved. Thank you, everybody.
Have to get your gavel back from him. Told you I had to-